Hello and welcome. It is right on the minute, so we'll give about 30 seconds for a few more people to join, and then we'll get started today with our conversation. Okay, being that we have a lot to cover today, and we want to leave time for some questions and answers, let's get started. My name is Ellen Miller, and I am the Pro Bono Manager at National Immigrant Justice Center. Happy New Year, and welcome back to the Policy Corner. NIJC's Policy Corner is intended to engage our communities on updates in immigration issues, and law and policy, and how it impacts our clients. Kind of goes without saying that 2020 was a year of unexpected changes and disruptions, and 2021, well, a lot has already happened in these 12 days. First and foremost, we hope that you and your loved ones are well, and that you continue to take care of yourselves. We recognize that bandwidths are stretched right now, but we do continue to push through with important conversations. And today we're gathering for a discussion on how to sever criminal, legal, and deportation systems. I'm very excited because today you're hearing from some of my excellent colleagues from our policy team, Heidi Altman and Naina Gupta, and from our litigation team, Mark Fleming is joining us. Before we go on to talk about what we're going to talk about today, a few things if you're not familiar with GoToWebinar. So right now, everybody is muted, and we definitely welcome and encourage you to drop your questions and comments in the chat function. Our team will be monitoring and responding to those throughout the conversation, and we'll leave time for questions and answers at the end as well. If we don't get to your questions today, we will follow up via email. The presentation is being recorded, and the link to the recording, as well as any materials that are referenced in the presentation, will be sent in a follow-up email, and the presentations are posted on our webpage, as well as all of our other policy corners if you want to go back and check those out too. I think that's it for webinar issues. So I'd like to just spend a minute explaining NIJC for those of you that are not familiar with us. At NIJC, our vision is that immigrants have the opportunity to gain rights and privileges of living in the United States, and that they can do this by participating in a humane and just immigration process. We believe that the pursuit of this justice must be responsive and accountable to the lived experiences of NIJC clients, their families, and our broader communities. Over this last year, we have served over 10,000 non-citizens, and these services have ripple effects with their families, their communities, and the larger society. At NIJC, as you'll see in this slide, we operate with an integral service model that combines aggressive federal impact litigation, zealous advocacy and policy work, as well as an expansive array of direct representation with legal services. And of course, we can only do this with our network of 2,000 pro bono attorneys that are active on these cases as well. We do have 5 offices across the United States while we're headquartered in Chicago, and I'm very excited to see a number of our partners joining the call today. We know that the work that we're doing is a marathon and it's not a sprint. And the efforts to promote a narrative that value human rights, strength and diversity, and due process is critical. So thank you for joining us today. Without further ado, I'm going to turn it over to Heidi to get us started.
Thank you, Ellen. And as always, a huge thanks to everyone who's on this call and devoting an hour of your time to be with us and think about these issues. Usually at this point in the presentation, we would focus on the agenda and give you a little roadmap of where we're heading. And we're going to do that in 1 second. But before we do the roadmap, we wanted to just spend a second on the question of what is this topic? Why are we talking about it today? You'll see at the top of the slide that I'm referring to right now the term crimmigration, which some of you may have heard of and has sort of cropped up in the past couple decades to refer to the many ways in which the criminal legal, what is often referred to as the criminal justice system, and the immigration systems not only overlap, but in many ways have sort of become one and the same. And I think for any of you who have been in an immigration detention center or have represented someone who is or was detained at one point, this probably feels pretty obvious to you, is that the person who you are working with, or maybe you have experienced this yourself, who's in the middle of the administrative immigration system, looks like they are in the identical circumstance to someone going through the United States criminal legal system. So I'm gonna just break down 3 different sort of component parts of what we mean when we use the term crimmigration today. Crimmigration refers to the ways in which immigrants are broadly criminalized in the United States, conflated with criminality simply because of their place of birth or citizenship. And that happens in sort of 3 big ways that we're gonna break down. The first and maybe the most obvious is that the actual act of migration, the act of entering the United States without authorization in that moment, is criminalized and prosecuted in the United States. And we're going to spend less time talking about that today because we've had a previous policy corner devoted entirely to the problems and racist roots of the laws used to prosecute unauthorized entry in the United States. The second main category, which I'll turn to in a second, is the many and extremely harsh immigration penalties that are attached as essentially a second punishment to any involvement in the criminal justice system in the United States. And then the third bucket, which my colleague Nana is going to talk about shortly, are the ways in which local law enforcement agencies like jails, sheriffs, and police officers collaborate and cooperate with federal immigration enforcement. So that's sort of an overview of what we're talking about today, and that helps us segue into the agenda. So in the next slide, if you don't mind clicking us over, Ellen, we're going to do a deep dive into the policies and the laws that exist today that over the course of decades have led to this conflation of the criminal, legal, and immigration systems in the United States. We're going to talk about the impact that those laws and policies have on NIJC clients and immigrant communities more broadly. And we're going to talk about the work that NIJC is doing, in many cases in collaboration and cooperation with a lot of you, toward finding a better way through litigation, through policy work. We wanted to take a moment to do some centering before we move into that conversation. And I know that this has been a difficult few weeks for all of us in different ways for everyone. And what we're talking about today are systems that work in front of a backdrop of many of the pathologies and inherent biases and systems of structural racism that have created many of the problems that led to the violence of the past few weeks. In the slide in front of you, you'll see that we recall an op-ed that was written in the New York Times last year by Michelle Alexander, right at the 10-year anniversary of the publication of her book, The New Jim Crow, which some of you may have read. And in that op-ed, she describes the cycle that our nation is trapped in, and she calls it a cycle of racial reform, backlash, and reformation of systems of racial and social control. And in this piece, she really explicitly connects the mass incarceration crisis and emergent white supremacist rhetoric in the United States to the criminalization of immigrants and systems of mass detention and deportation. So we're going to take 2 to 3 minutes before we begin, and I'm just going to read out loud and ask each of you to read along with me this quote from the piece, and then we're going to ask everyone to take a minute if you want, either in your own space or mind or on a piece of paper or in the chat box that you all have on GoToMeeting to reflect on a question. So here is what Michelle Alexander wrote. White nationalism at its core reflects the belief that our nation's problems would be solved if only people of color could somehow be gotten rid of or at least better controlled. In short, mass incarceration and mass deportation have less to do with crime and immigration than the ways we've chosen to respond to those issues when Black and brown people are framed as the problem. So a lot of what we're going to be talking about today are the ways in which a citizen and a non-citizen who are arrested for the same criminal offense in the United States would face dramatically different consequences. One might do a week of community service and the other might be forever expelled from the United States and separated from their loved ones, simply because of their birth. What concerns does this raise for you, just off the top of your head, when confronted with that question, with the quote from Michelle Alexander in the background? And we'll just take like 2 minutes. If you want to just do your own quiet reflection, or if you want to put some thoughts in the chat, either or both are wonderful. And then we will move into the substance of the presentation today. Okay, I'm gonna start moving through the presentation and ask that and leave the the chat box open as an open forum for folks to share thoughts and reflections as we move through today. So what we're going to do now is move into the sort of conversation of state of play and overview of the law and policies that make up the overlapping systems that we're discussing today. So going back to the sort of 3-bucket frame that I began us with, the prosecution of the actual act of migration being the sort of first realm which conflates the criminal, legal, and immigration systems. We're not going to focus on today, but in our follow-up materials, we'll refer you back to our past policy corner. The next bucket are the ways in which a person who is either charged with criminal conduct in the United States or ends up with a criminal convictions faces very severe immigration penalties on top of whatever penalties are assigned to them through the criminal legal system. There's really 2 categories of types of convictions that are listed in the federal immigration law that can either prevent people from ever being able to enter the United States or gain legal status here, or that can trigger the penalties for those people who are already in the United States of immigration detention, which we've covered on many past policy corners is really a system of incarceration, deportation, and eventually the prevention from being able to return to the United States. The categories of convictions that give rise to these penalties in the Immigration and Nationality Act are listed in very vague and often confusing terms of art. They're incredibly overbroad. And an example that I often give is actually one of my first clients I ever had when I started practicing was a young man who had been a green card holder in the United States for his whole life, traveled to his home country for his grandmother's funeral, and then at the airport when he was coming back was stopped and put in immigration detention and deportation proceedings for one marijuana possession conviction that he had. And I would later find out that nearly anyone who's practiced in deportation defense has had at least one of the clients who went abroad for a funeral and came back and was stopped for marijuana-related offenses. And that the penalties that then flow are layered on top of whatever sentence was imposed by the criminal court judge for that first conviction. Moving on to the next slide, we just want to flag as part of this conversation that many of us anticipate that in the next congressional session, there may be, or we hope there will be, a possibility of a legalization package for many of the members of the undocumented community in the United States. And that over the past 10, 15 years, draft legalization programs have really proven sort of fertile ground for legislators to experiment with making these lists of convictions that trigger immigration penalties even more expansive in the ways that they would bar a person from applying for or obtaining protection through a new legalization program. So I'm not going to go through it in detail. We'll send you some follow-up materials, but the chart that you see in front of you right now is a sort of flow chart that looks at one recent legislative proposal that would have granted legalization protections to DACA recipients and temporary protected status recipients that took the already overbroad grounds of inadmissibility in the Immigration and Nationality Act and layered numerous additional bars on top of them, making it nearly impossible for anyone who has previously been involved in the criminal legal system to even consider approaching an application for legalization. So that's a broad take on the ways in which a conviction triggers numerous immigration penalties. For the sort of third bucket that I originally started off, which is the pipeline that forms between the criminal legal system and the immigration systems, I'm going to toss it over to Nina Gupta, who's our Associate Director of Policy.
Thanks, Heidi, and hi, everyone. So grateful to have you join us here today. So, when we talk about the interaction of these two systems, it is helpful to understand the exact programs and policies that actually move people from the criminal legal system into federal immigration enforcement. These are the programs and policies essentially where ICE works with local law enforcement to identify and hold immigrants that come into contact with the criminal legal system so that federal immigration authorities can then shuttle them through the deportation and detention system. So first, across all of its programs, ICE relies heavily on what we call immigration detainers, which are also sometimes referred to as ICE holds. An ICE detainer is a request that the federal government, that federal immigration authorities make to a local law enforcement agency, like a local police department, asking that the local agency hold an immigrant in local criminal custody in jail beyond their set date for release, so that ICE has time to show up and transfer that person into immigration jail because the agency believes that person is deportable. This act of holding someone beyond their scheduled release date has been found by courts and is accepted to be a new arrest of that immigrant in the criminal legal system. In 2019, ICE logged more than 160,000 detainers with local law enforcement agencies, which gives you a sense of how heavily the agency relies on detainer practice to support its enforcement priorities and practices. In addition to this detainer practice, which cuts across many programs, the 287G program is a specific program used by ICE. It's a formal agreement between the agency and specific local law enforcement agencies that deputizes local law enforcement officers to act as federal immigration officers. So in other words, local police themselves can issue immigration detainers. They can interview immigrants in criminal custody about their immigration background. They can even check federal databases for immigration information about people. They are, in other words, loosely trained and given power to act on behalf of the federal government around federal immigration enforcement. As of October 2020, so just a few months ago, there were 77 active 287G agreements nationwide and another 75 mini versions of these agreements. And in 2018, the federal government appropriated $24.3 million to support this program, which has really flourished and was promoted particularly under the Trump administration. In addition to 287G, many of you may be familiar or have heard about the Secure Communities program. This is a program in which local law enforcement agencies around the country are required to share with ICE fingerprints of individuals arrested for a criminal offense. So usually when a local police officer arrests someone, they take fingerprints and then share those with the FBI. ICE then compares those prints to notoriously inaccurate databases and decides who it thinks is deportable, and based on that issues this ICE detainer or a request for a hold to the local law enforcement agency. Secure Communities, in other words, is the program that has been used most widely to support the agency's use of detainers and holding people at the local level. The program began in 2008 under the Obama administration, but was terminated in 2014 because of significant evidence showing that the program had led to racial profiling by local officers, undermined community policing efforts, and resulted sometimes in the unlawful detention of American citizens. However, in its place, the Obama administration started what's known as the Priority Enforcement Program, PEP, which in practice was really not significantly different from Secure Communities, as ICE itself admitted in litigation. Although PEP 2 was discontinued because of many of these same complaints, the Trump administration at the beginning of its term reinstated Secure Communities as mandatory for local governments. In addition to these programs and detainer practice, another way we see these two systems interact is through restrictions on federal funding. So in attempt to secure cooperation from local governments, especially ones that have been resistant in the past 4 years to working with federal immigration authorities by enacting sanctuary policies, the Trump administration has made federal grants contingent on compliance with immigration enforcement priorities. So to be clear, in order to receive federal funding, local police departments have to follow a certain set of anti-immigrant policies and practices. All of these mechanisms that I'm talking about are relatively recent in immigration history. It hasn't always been this way, and that's something that we emphasize at NIJC when we talk about dismantling the interconnectedness between these two systems. We know that an immigration system can exist without this reliance on the criminal legal system, while the roots of the entanglement comes in part from the racism of the Reconstruction era. These specific policies and programs I just described are relatively new in immigration history and were really put into place as a part of the war on drugs in the 1980s. We heard politicians on both sides of the aisle at that time use racial stereotypes and dehumanizing language to mobilize public support for harsh criminal sentencing laws that affected low-income people of color especially. And while this was happening, Congress was simultaneously passing legislation and starting programs criminalizing immigration. So when we if we can move to the next slide, when we do talk about dismantling these two systems, these programs and policies are obviously important to understand, but what is most helpful to bring to light how this works is to understand the lived experiences of the people who are impacted by these systems. So here on this slide, this first article that you see referenced here in The Guardian discussed folks who could benefit on the criminal legal side from US drug reform, but who nevertheless were facing onerous and harsh conditions on the immigration side. So these were legal permanent residents whose prison sentences were reduced, but where ICE officials nevertheless found no compelling reason to show them any kind of compassionate release or to prevent their removal from the country. Similarly, the story below is of an NIJC client, Fernando, who moved to this country from Mexico decades ago after surviving a violent home invasion by local law enforcement and a series of family tragedies, suffered from depression, became addicted to drugs. He found himself convicted of drug possession, but completed the criminal sentence he was given, only to then be turned over to ICE and to be put into deportation proceedings. Fernando has been jailed by ICE for twice as long as he spent in criminal custody, all while separated from his family and without the opportunity to rehabilitate in his community. Similar to these two stories, an additional NIJC client with a powerful story is our client, Robert Panton, who's a 54-year-old man who was recently granted compassionate release after being incarcerated for almost 30 years because of a non-violent drug offense he committed in the late 1980s. He was granted release due to COVID-19 and the fact that he'd served this onerous sentence for a non-violent drug offense. But instead of being allowed to reunite safely in his home with his family, he was immediately transferred to ICE custody and is now facing deportation proceedings and prolonged immigration detention. He's been in ICE custody since early August. He is at heightened risk of contracting COVID-19 because of a history of pneumonia, high blood pressure, Legionnaire's disease, and other significant medical conditions. During his years of incarceration on the criminal legal side, he pursued numerous self-improvement programs, education programs, volunteered to give back to his community, maintained a close relationship with his 3 children who are now grown, and advocating for his release from immigration custody because they are eager to be reunited with him. And so when we advocate, again, for separating these two systems, these are the stories that we tell and share, but we also emphasize why it's important now in this moment to separate these two systems. So on the next slide, we talk about, the very clear racial justice imperative for separating these systems. In the wake of this past year's racial justice protests, there is a rising public consciousness and acknowledgement of what we have known to be true for decades, that the criminal legal system is infected with racial bias and discrimination at every stage, from the time of arrest through adjudication and into sentencing. By conditioning immigration consequences on decisions made in that system and relying on local police departments to do the work of enforcing civil immigration laws in the way that both Heidi and I have just discussed, we transfer the criminal legal system's structural racism and bias into the immigration system, which is unjust and unfair, but also delegitimizes the immigration system. This also imposes a double punishment on immigrants who enter the criminal legal system. Citizens entering the system may be charged with the same offense, receive the same sentence as an immigrant, but the immigrant in the criminal legal system then is subjected to this double punishment of deportation and detention because of this cooperation and coordination in the pipeline between the two systems. And this has been covered, for example, in this Atlantic piece that talks specifically about Black undocumented immigrants and the disparity in representation of Black undocumented immigrants in our immigration system. In addition to this racial justice imperative, the other big reason to separate these systems, if we're on the next slide, is to dismantle and flip this public safety narrative that we hear a lot from policymakers and politicians, who often justify the criminalization of immigration based on public safety, that somehow these policies and programs make us all safer, when in fact a large body of research and evidence directly contradicts this. What the research shows is that safety is best supported at the community level by policies that nurture immigrant inclusion rather than encourage deportation and detention. We know that social capital that immigrants invest in their communities actually correlate with lower crime rates when other factors are controlled for. This is referred to in social science research as the immigrant revitalization perspective. We also know that sanctuary policies of the kind that we saw enacted under the Trump administration at the local level contribute to enhanced safety, and that when we have local law enforcement officers, local police working with federal immigration authorities and with ICE, that breeds community level mistrust. It means that immigrant families are less likely to report instances of domestic violence or other crimes. They're less likely to trust public institutions for benefits and supports they need to contribute to their communities, which leads to an overall destabilization of communities. And so with that, I'm going to turn the mic over to Mark Fleming, who's the Associate Director of Litigation here at NIJC, who will talk more about the work that we've been doing in courts and through litigation to tackle the entanglement between these two systems.
Yes, hi everyone. So as Nina was saying and laid out nicely what the problem is and where this intersection and pipeline from the criminal justice system into immigration, the immigration deportation system, there's this link through immigration detainers, principally immigration detainers, where people are shuttled from the criminal justice system, even for the most minor of interactions with law enforcement, to potentially permanent separation from their families. And so for over a decade now, one of the tools we've been using to challenge this link with respect to immigration detainers is litigation. We've done it both in federal courts with a lot of colleagues from around the country, and then also in state courts. With respect to challenging detainers in federal court, the claims tend to be Fourth Amendment violations is what we focus on. So we have raised most recently in a class action that is effectively a nationwide class action in the Southern District or Central District of California called Gonzalez v. ICE with our co-counsel, the ACLU of Southern California, a series of Fourth Amendment claims as to ICE's use of immigration detainers. Number one, we argue in that case that ICE's use of databases that are woefully inaccurate and have significant incomplete and gaps in its information are insufficiently reliable to make probable cause determinations that a person is a non-citizen and removable from the United States. Second, we argued that state and local law enforcement don't have arrest authority, and thus they are making unreasonable seizures when they honor immigration detainers under the Fourth Amendment. And then number three, that because detainers are warrantless arrests, that ICE is not following the requirement that there be a prompt, detached, and neutral determination of probable cause. That case, Gonzalez, recently was up at the Ninth Circuit. The case with respect to the databases being flawed and incomplete has been remanded to the district courts for further proceedings and factual development. We feel fairly confident that we can do that and win that claim. Unfortunately, the Fourth Amendment claim with respect to lack of arrest authority was overturned by the Ninth Circuit, and I think unfortunately correctly based on some Supreme Court precedents. And then finally, and which was a really kind of a big breakthrough, is the Ninth Circuit agreed with us that because these are warrantless arrests, the protections under the Fourth Amendment with respect to getting a prompt judicial determination of probable cause, either in the form of a warrant or afterwards in the form of a hearing, should extend to civil immigration arrests. Unfortunately, up till now, that had not happened. And so it's been remanded for further application of that principle under the Fourth Amendment, but we feel confident that we can get it to apply just like it does in the criminal justice system. And to the extent that we win on these Fourth Amendment claims, the real goal is to end that coupling of the criminal justice system with civil immigration enforcement. And then, and as part of that case out in the Central District of California, we also had a companion class action against the Los Angeles Sheriff's Department, in which you can see on the screen here, we ultimately settled that case for a $14 million judgment based on their 6 years of honoring immigration detainers unlawfully. And so, you know, the other strategy here has been to bring damages claims against state and local law enforcement to show that they have real liability should they be doing the work of immigration. And then the other strategy, as you'll see, is state law violations, which is that, as I said, state and local law enforcement, as a general principle, do not have authority to make civil immigration arrests, either unilaterally or even in cooperation with ICE. There is only a handful of states that have authorized it. And so we have been, with partners around the country, have been going state to state in state courts to say, when state and local law enforcement are honoring this, they are violating state statute, and have been successful in a series of cases, starting in Massachusetts and New York, which, you know, we might expect that there, but then most recently in the state of Montana, you know, a unanimous Supreme Court in Montana agreed that the state and local law enforcement there do not have authority. And so we feel like this is a really promising theory that can decouple that connection, and one where, you know, the possibilities of sanctuary laws or these sorts of things where they choose to not participate in immigration are less likely as a political matter. And so I'm going to hand this back, I believe, to Heidi to discuss some of the policy work that we're doing around these issues.
Thank you, Mark. And thanks to everyone for the rich Q&A. Please keep them coming in the chat as we're going. So, you know, building on the sort of what are we doing about all this, in addition to Mark and others. Oh, I'm not on video, sorry. Litigation work. We're moving forward a lot of different policy proposals on these issues. And like all the work we do in our DC office, we have an approach that marries legislative with executive branch advocacy. And so I'm going to talk about a bill that NIJC has been working on and supporting since it was first introduced, actually just about a year ago. We just met the 1-year anniversary that will be introduced again this session. And then Nana is going to talk about some of our proposals for executive action. And there was a note in the chat about, you know, sort of at the basis of all this, the need for legislative change. And we do echo that call. The bill that we have been working on, which I'm putting a little bit more information in the chat about right now, is called the New Way Forward Act. And this is a bill that is led primarily by Congressman Chuy Garcia in Illinois, along with Congresswoman Pramila Jayapal, Congresswoman Karen Bass. You know, we think a really exciting step toward remedying a lot of the problems we have solved today. There's basically 5 pillars to the New Way Forward Act. It first ends mandatory immigration detention or no bond detention, where a criminal conviction can trigger mass and prolonged incarceration of an individual without the opportunity for an individualized assessment of release. Second, the law ends the kind of automatic pipelines that Nana has been talking about today by repealing many of the worst, most vague and overbroad categories of offenses that trigger that trigger removability or deportability. In particular, for those of you who are familiar with immigration laws, the crime involving moral turpitude, grounds of removability, and any drug-related grounds other than drug trafficking are removed. And it also ends automatic deportation and summary proceedings. So there's a real focus in the New Way Forward Act on restoring due process to the system by making sure that there is no moment where a criminal conviction means that a person is shuttled through to deportation without at least the opportunity to present the positive equities in their case to a judge. And then the last 2 pillars of the bill are an end to the practices that you also heard Nina talk about today, programs like 287G and secure communities where local law enforcement are cooperating actively with federal immigration enforcement would be ended. And then lastly, a repeal of Section 1325 and 1326, which are the federal statutes used to prosecute unauthorized entry. And so that bill is going to be reintroduced in this Congress in coming weeks. And you'll see information about a press conference and other information on our website that will be excited and probably asking folks to consider calling and asking your member of Congress to support at some point over the year. That's the legislative front. And for our executive action asks, I'm going to toss it back to Nina.
Yeah, thanks, Heidi. So it's definitely true in response to that great comment in the chat that we need this kind of major legislative change to start tackling disentanglement of the systems. But in our advocacy, what we also make clear is that there's steps a new administration can take right away to start mitigating the harms that we're seeing for our clients between these two systems. And so in a paper that a policy brief that we've recently written that we will send to the group after this presentation, we offer 8 specific executive actions that can be taken under the new administration, which include ending in full the use of immigration of ICE detainers and holds that I just described earlier, terminating the 287G program. Again, these are all actions that the executive branch and the agencies can take without any kind of interaction even from Congress. They can take these actions on their own. Ending secure communities and all other similar programs. And a kind of agreement that I didn't discuss before are basically also agreements for bed space in local county jails. So in order to detain as many folks as the government detains right now, as immigration authorities detain, they rely often on bed space at the local county jail level through contracts with local jails. And sometimes private facilities. And these are agreements that the executive branch could just terminate so that there's less bed space to decrease the number of folks where we are placing into detention. And then finally, we do recommend creating a commission who would really study and analyze all of the various databases and mechanisms of information sharing that happen through technology between the federal government and local enforcement authorities in light of how inaccurate these databases are, in light of how they violate the privacy of immigrants, of how they put our local communities at risk. In addition to these legislative and executive actions, there's a lot of work to be done at the state and local level. So I'm going to turn it over to Mark, who'll talk a bit more about that. Are you there, Mark? Okay.
Yes, apologies. I had a few intruders who were looking for me. E-learning is a unique experience. And then we will continue to work on state and local legislative efforts. I think these are what are colloquially referred to as sanctuary jurisdiction laws. And to folks that are not in Illinois, obviously that's where we are headquartered, we offer technical assistance on legislation across the country and have continued to. And so in recent years, we've worked on bills that banned private prisons, for example, in Illinois. But in the coming year, we continue to look to block the loopholes of this intersection between state and local law enforcement. And so, for example, we're working on a bill called the Illinois Way Forward Bill, which is looking at ending the communication and other forms of cooperation other than, say, arresting on immigration detainers. And we will continue to do that both here locally, but offer our services to provide technical assistance on other types of legislation like that. And I would like to flag that, a lot of this legislation really focuses on what, we think of as states' rights or 10th Amendment theories, which, historically were, a conservative project, but, have proved quite successful in creating pathways of hope on immigration policy in what has been a very admittedly difficult time for immigrants.
Okay, that was just a stream of wonderful information, and I'm really excited by just kind of the overall view of what's happening across the country locally. And what we're doing about it. So thank you, Nina, Heidi, and Mark. And now just as we always try to wrap up these presentations, right before we jump into the Q&A and address some of the really great questions that have been asked here. I wanted to highlight other ways that this community can get involved and stay involved. Of course, attending these presentations and sharing them, sharing information, continuing to promote this, this narrative of justice and due process. We ask you, if you're an attorney and can represent a client and help us in the representation of cases, we have currently 55 matters on our case list that are looking for pro bono representation, and continue to communicate with your members of Congress, your representatives, both statewide and also at the federal level. So without that, or without anything else specific right now, I'm going to jump into the Q&A. One last kind of logistics task right before the Q&A is, we do value your feedback and we really appreciate the questions that are flying through here. But if you have feedback on the presentation, are there other topics you'd like to see or the way that this is rolling out, please just hold up your device to that QR code right there. And you can get it done real quickly. It's about 4 questions, and we appreciate your comments there. So we have a number of questions coming in, and I'm going to do my best to get through them. Of course, the panelists can also jump in and comment. We're going to start with a question here from Beth, and is talking about, obviously on the front of our minds is the transition period. And I'm going to throw this to Heidi right now. And if you could comment on how likely is the Biden administration to work through these executive orders, and what other organizations is NIJC partnering with to promote this work?
Yeah, thank you. So I think we were watching really closely over the course of the campaign for commitments that might be made by what's now the incoming administration. President-elect Biden made at one point during a debate, like a not particularly specific commitment, but that was about ending cooperation between local law enforcement and federal immigration enforcement. And we don't have any more specific commitments than that. But we are working across a couple of different coalitions with numerous partners. We work closely with organizations that I'm sure a lot of you also work with and support, and I'm going to name, but this is not exclusive. The ACLU, the American Immigration Council, United We Dream, Undocu Black, Human Rights First. There's a really healthy, vibrant collection and coalition of national immigration organizations working together to make sure that these policy proposals that you've heard us talk about today are like very much front and center. And day one, when the administration comes in, and we've been transmitting them to the transition team, and we'll continue to push once the administration is in place. I'm also I noticed that before we toss to the next question, I noticed there was a question about book recommendations. And so since we're talking about coalitions, I'm just going to make a quick shout out to our wonderful coalition partner, Alina Das, who is also an immigration professor and clinical professor at the NYU School of Law, and has like literally written the book on these issues. And so I'm going to put it in the chat if any of you are interested in reading more. It's a great place to start.
Thanks, Heidi. Good books are great during quarantine, right? There was one clarification that was asked, also what we meant when we said terminate jail agreements. And we just want to make sure that our terminology is clear here. So we did say that, Heidi has clarified for us, and Mark too, that as the many local jails contract with ICE, with Immigration Customs Enforcement, they're allowing ICE to use the local jails. Right, and so by terminating the jail agreements, we just mean ending these contracts. The federal government would end these contracts. So, Mark, I don't know if you have anything else to say on that. And then also the question from Jessica today: if you're aware of any viable challenges to crimination consequences based on the Eighth Amendment, and the Eighth Amendment theory of excessive punishment. Can you comment anything on that?
Yeah, so I mean, with respect to the detention contracts, they tend to come in 2 principal buckets. I mean, one of the things that is interesting and troubling about the immigration detention system is that ICE does not own or only owns and operates 4 or 5 of the detention facilities out of the 200 to 250 facilities. Disproportionately, they contracted out through what are called intergovernmental service agreements with typically county jails or 2 private prison companies, or passed from an IGSA into a private prison company as a subcontractor. And so while it's deeply troubling as far as accountability, it provides opportunities given that state and local law enforcement do not need to be cooperating in doing this. And so there are real opportunities to have site fights with state and local law enforcement to end those sorts of contracts. And likewise, as you've seen, in California and a version of it here in Illinois, there are opportunities at the state and local level to end the use of private prisons at the, through state and local without a change at the federal level. With respect to the 8th Amendment arguments, I'm not aware of any in the context of the actual underlying idea of whether a person is removable or not. Certainly we bring detention conditions arguments that are actually not 8th Amendment in the civil immigration context. They're actually under the 5th Amendment. And at least they should be treated with a more lenient standard, i.e. that there should be better conditions of confinement in the civil immigration context. Of course, we know that that's not necessarily true, but we do see those sorts of arguments, but I'm not aware of any effort with respect to 8th Amendment arguments as to the removal proceedings and decision to remove itself.
Thanks, Mark, and thanks for the great questions. So I'm going to move on now and shoot one over to Naina. Naina, we have a question here from Tracy that refers back to your mentioning of racial discrepancies in adjudication and sentencing. Would you be able to comment a little bit more on how non-citizens are affected by those discrepancies and how that makes them more likely for deportation and other immigration penalties?
Sure. So yeah, it's a great question. The connection between the racial disparities we see in the criminal system and what that really means for immigrants. So just to be clear, right, what we know in terms of discrepancies on the criminal side, even before the adjudication of a criminal case and the sentence somebody receives, we know that both Black and Hispanic individuals in this country are more likely to be stopped by police than others, and that once pulled over, Black and Hispanic drivers, for example, are 3 times as likely to be searched, and Black drivers twice as likely as white drivers to be arrested. We know that a Black individual in this country is almost 10 times as likely as a white individual to be arrested for non-violent, low-level criminal offenses. And so what this means is that Black and brown people generally are becoming involved in our criminal legal system through this discriminatory pipeline. And so Black and brown immigrants are more likely to be represented in the criminal legal system, to be arrested, to be picked up, and then continue to face bias through the course of the system, resulting in a conviction or a sentence that then triggers deportation because of these laws that Heidi has described, and are brought to the attention of federal immigration authorities because of these programs that I described. And so, yes, the discrimination and disparities we see for people of color in the criminal legal system definitely make immigrants of color, Black and brown immigrants, much more vulnerable to deportation and detention. And that's why we see an overrepresentation of Black and brown immigrants in the immigration system. And we talk about the double punishment that they're facing as compared to other folks who enter the criminal legal system.
Thanks. I'm going to now switch over to a question about basically sanctuary cities, and I believe it's Sanjo. Excuse me if I mispronounced that. But Sanjo is asking about kind of the anger and the the actions of the federal government for refusing to comply with Section 287G enforcement, and the city of Chicago in particular, you know, as an example. What is happening with those with those cities and those discussions? Mark, do you maybe want to start there, and then Nana, of course, if you have other things to add.
Yeah, so the fight was really over sanctuary laws, which are really, I mean, it's kind of a misnomer in the sense that sanctuary, it's not as if they are prohibiting immigration enforcement, but really are laws about at a state and local level, we just don't want to participate in this. And it is their prerogative under the 10th Amendment and states' rights in our federalist system to not participate in that. As folks are well aware, this was, you know, something that has been heavily litigated over the last 4 years as the current administration tried to condition federal law enforcement dollars. So there's various federal law enforcement grant programs where they provide aid to state and local law enforcement. They were conditioning it on various forms of cooperation with civil immigration enforcement. Really a truly unprecedented attempt to do something like that. So far, and it's not completely over yet, at least 3 courts of appeals have ruled against the administration in finding that there was no authority to be placing those conditions. So anytime you're talking about federal money, it's Congress's prerogative to set conditions. And obviously the most classic one being conditioning federal highway dollars on changing the age of the drinking age at the state level. These programs, these law enforcement programs, didn't have any of those sorts of conditions set by Congress. And so at least 3 circuits have denied that and rejected it outright. And in fact, there's a nationwide injunction from the 7th Circuit on it. The 2nd Circuit, unfortunately, in a kind of bizarre opinion, went the other way. So there is a cert petition actually at the Supreme Court right now. Now, obviously, the change of an administration, they can end this on day 1. They can just say, going forward, we're not going to have these conditions, and that will be the end of it. And I think we remain hopeful that that's what's going to happen.
Thanks. Nina, did you have anything else to add there? No? Okay. I think then if, you know, I think to respect everybody's time then, we're going to wrap this up here. And we definitely appreciate the great questions. We've tried to answer most of them in the chats, and we very much look forward to seeing you next month. So I believe it's February 9th. It's just a few weeks away. And in the meantime, be well, and we'll see you in February. Thank you.
Thanks, everyone.
Thanks, everyone.
Thanks so much.